coming on here. Thanks to Nécole Key. She's in the chat room right now, for being down. You know what I'm saying? Because it's rare that you find people that are down. She down for you. Like she want to see you win. You know what I'm
Yeah,
saying?
man. God has sent that girl, man, and man, she's been hanging in there with me, man, through thick and thin. I really appreciate that, young lady.
Welcome to the Deep Dive. Today, we're plunging headfirst into a legal battle that didn't just win back some iconic hip-hop masters. It basically rewrote the rules for artists everywhere.
We are talking about 2 Live Crew, and this was not your standard royalty dispute, not by a long shot.
No, this was a fierce, years-long fight over their copyrights, and it got incredibly complex.
It really did. You have intellectual property, the 35-year termination window, a lot of money, and this one, really thorny defense that catalog owners use, bankruptcy.
Right. The central question was, can an artist's future right to reclaim their work be legally wiped out just because their manager or label went bankrupt decades earlier?
And our mission today is to figure out how that huge legal hurdle was overcome. We're going to be guided by a really unique set of sources.
Yeah, we have a cache of emails from 2019 to 2024 between the artist manager, Nécole Key, and the lead attorney, Scott Allen Burroughs.
And these emails, they show Nécole Key as the real strategic engine of this whole thing. It's a masterclass in how research and just sheer diligence can lead to a monumental win.
So let's start at the beginning. The source of the conflict.
Okay, so one of the original members of 2 Live Crew, brother Marquis Mark Demetrius, was basically told his rights and his royalties were gone.
Just gone.
Yeah. Sold to an individual, Joseph Weinberger, who runs Lil Joe Records. And the reason given was that the group's original manager, Luther Campbell, and his label, Luke Records, had gone bankrupt.
And that bankruptcy sale happened way back in 1996.
Exactly. And that's where the trouble started. When assets are sold in bankruptcy, they're often sold free and clear.
That phrase is just, it sounds so final, free and clear.
It's terrifying for an artist because the buyer then claims that the rights are wiped clean of everything, liens, any other claims, and most importantly, the artist's future right to terminate the copyright.
So they're essentially saying they bought the work forever, and that 35-year termination window the law is supposed to guarantee, it just doesn't apply.
Precisely. It's a common defense. But this is where Nécole Key comes in. She knew what she was looking for.
She really did her homework. That first email she sent to the attorney in May 2019 is incredible. She didn't just ask for help, she came with a legal blueprint.
She'd read his article on copyright termination. That's why she reached out. She had already identified the exact piece of the law she needed.
Copyright Law Section 203.
That's the one. Section 203 is the lifeline. It gives authors the right to get their copyrights back 35 years after they first transferred them.
And she was looking at the timeline. The album 2 Live Crew Is What We Are came out in 1986. She knew the window was opening. She wrote that it was, quote, nearly ripe for termination.
But the attorney, he immediately raises the red flag. He's heard about this bankruptcy. He mentions a blog post from a group member saying the rights were sold free and clear.
So this wasn't going to be a simple termination filing. This was going to be a fight over whether a right that hadn't even come into existence yet, that hadn't vested, could be wiped out by a past bankruptcy.
And that set the stage for everything. The attorney's initial hesitation just highlights how risky this was. They were going up against decades of sort of accepted practice in bankruptcy courts.
But Nécole didn't back down. She became the engine of the case.
Absolutely. Through 2020 and 2021, she wasn't just managing, she was the core resource for the legal team.
I mean, she was the one digging through all this old paperwork to build the paper trail. Think about that. Trying to find a specific document from, 25 years ago?
It's a huge task. And she found the crucial ones. The original 2 Live Crew contracts, and most importantly, the 1996 Joint Plan of Reorganization for Luke Records.
And why was that document so important?
Because that plan laid out exactly how the assets, including the copyrights, were handled in the bankruptcy. Without it, you can't prove the direct link between that first transfer and the later owner's claim. It would have been almost impossible.
And then, when they were actually preparing the termination notice, her attention to detail was just next level.
Oh, absolutely. She was leaving nothing to chance. She's emailing the lawyer, asking about every single technicality. Is the corporate name Pac Jam Publishing? Or is it Luke Records? Or Skywalker?
Because any little mistake could give them an excuse to deny it.
Exactly. And she was so meticulous about the titles. She insisted they include every single variation for the group's name, the new 2 Live Crew, the 2 Live Crew, and for all the big works.
As clean as I want to be, as nasty as they want to be, banned in the USA.
Oh,
All of them.
all of them. She literally wrote in an email, "I'm trying not to give them any reason to deny us. That's not a manager, that's a strategist."
And that strategy was put to the test almost immediately.
It was. October 2021, Lil Joe gets the termination notice and responds by filing a lawsuit in Florida.
Trying to get home court advantage.
Of course. But Nécole immediately starts firing back with countermoves.
She didn't miss a beat. She's pushing to get the case moved out of Florida, asking about a jury trial instead of a judge because she'd prefer a judgment by peers.
She was playing chess, and at the same time, she's gathering evidence for their own counterclaims. She brought up the irreparable damage done to Brother Marquis, even providing photos of a look-alike being used to impersonate him at shows.
Wow.
And she challenged their whole claim of ownership, arguing that even if they got the rights in bankruptcy, any documents her clients signed later were under distress.
So even with all this prep, they still had to face the biggest obstacle, that bankruptcy claim.
Right. This is the core of it. The entire case came down to proving that an artist's future right to terminate is not an asset that can just be seized and sold off in a bankruptcy auction.
And this is where that word unvested becomes the key to everything.
Exactly. Think of it like a ticket for a train that's not scheduled to leave for 35 years. You have the ticket, but you can't actually use the right to travel yet. The right hasn't vested.
So you can't sell the ride today.
You can't. But the label was arguing they bought everything, the present and the future. And Nécole's research was what helped tear that argument apart. She proactively started looking into other parts of bankruptcy law.
And she found something interesting.
She did. She cited Section 365N of the Bankruptcy Code.
Okay, break that down for us. Why does that section matter?
Well, 365N deals with intellectual property licenses when someone goes bankrupt. And what it does is it protects the person who bought the license, the non-debtor, from having their IP use terminated.
So she was connecting the dots.
She was. She saw that if the law specifically creates protections against IP termination in such situations, it means the law sees termination rights as something special, something distinct from other assets that just get liquidated.
She was so confident. In her email, she's telling the other plaintiffs that the bankruptcy argument won't be an issue because the law they're trying to use actually excludes copyright in this context.
I mean, she said they spent a year going through all the possible what-ifs and laws they could possibly use. That groundwork is what led to the win.
And that win came on March 20th, 2024. The court officially rejected Lil Joe's main argument. That's the moment that changes things for the whole industry.
It's monumental. Because the court agreed, it said the termination right was unvested and that it existed entirely outside the scope of bankruptcy.
So it's a personal right. It belongs to the creative. It can't be treated like a piece of office furniture and sold at auction.
That's it. It solidifies that artists get their one shot to reclaim their work after 35 years, no matter what happened financially in the past.
You can tell from the emails this was so much more than just a business deal for her.
Oh, for sure. She framed it as a mission of faith. She even mentioned a previous success recovering rights for her client, Brenton Wood, in just 2 months. It clearly solidified her belief that if you use the law correctly, it works.
And while she's fighting this huge legal war, she's also having to manage the group's internal politics.
Which is a whole other layer of stress. She got compensation agreements from Luke and Nikki, but she noted that Chris Wong-Won's camp was just ignoring her.
It's a reminder that you're not just fighting the label. You're trying to keep your own side together.
Exactly. And she was thinking even bigger than the copyrights. She wanted the trademark back, too.
The brand name 2 Live Crew.
Right. She saw that the opponent had filed for the highest protection possible for the trademark, which she saw as a sign of weakness, a sign they were worried.
And she had some history on that, didn't she? She alleged they got the trademark by extortion, foreclosing on Chris Wong-Won home.
She did. She saw a clear path to contest that, too. But this is where a really vital legal distinction comes up.
Which is?
The law they use so successfully, Section 203, only applies to copyrights. The music, the masters, it has no power over trademarks.
So the name and logo are a totally separate fight.
A completely separate legal battle, and Nécole understood that. She eventually confirmed in an email that she'd taken the trademark issue off the table for that attorney, meaning she's handling it through other channels.
That's just incredible strategic focus. Okay, let's unpack this outcome. Nécole Key proved that deep knowledge and relentless research can change the future for artists, even against decades of industry control.
Her work in defeating that bankruptcy defense wasn't just helpful, it was the entire key.
So if we pull back, what's the bigger picture here?
The bigger picture is that this is a game changer for artists, especially ones who signed bad deals early on or had financial trouble. The court made it clear that future copyright termination right is sacrosanct. It can't be absorbed or wiped out in a bankruptcy.
So what does this mean for you if you're a creative or you work with them?
It means the fight for your work is often about persistence, about challenging these really entrenched legal ideas. And sometimes your best partner is the one who knows that case file inside and out.
Which leaves us with a final thought. Given how this bankruptcy loophole, a major shield for catalog owners, has been so definitively closed.
Right. It raises an important question. How quickly will rights holders now try to adapt their contracts and invent new defense strategies to get around an artist's termination right in the future?